let's look at different methods for transferring one's estate upon death. The most popular plan for transferring wealth upon death is no plan at all. 70% of the population has no will in place. And if that's the case, then their estate will be settled according to the laws of intestacy, which are the laws that govern the distribution of an estate without a will. But the state in which you live, their plan for your estate may be very different from the plan or the wishes that you have, so it's important to plan. A will, contrary to popular opinion or belief, is subject to probate and to court approval. Most people wonder why this is the case, because a will, it's in writing and it expresses your wishes, correct? But that's not the case. A will is a note of your wishes to the judge in probate court saying, if it's okay with you, judge, here's how I would like my stuff to go. Now, beneficiary designations are another method, very effective method for transferring ownership of an asset upon death, and a beneficiary designation avoids probate. So life insurance, IRAs, bank accounts that have POD and TOD beneficiary designations attached to them avoid probate effectively. Joint tenancy is another method that's used to transfer property, usually real estate and bank accounts, from one person to another. Now, it's not uncommon, for example, for a mom to have her daughter on an account as a joint tenant with her, so that if something happens to mom, it goes entirely to the daughter. Now, that's great. That survivor is the owner upon death, but what if mom's will said, I have 3 daughters and I want them to share and share alike? Because of joint tenancy, the one daughter is the sole owner of that account and is going to have to decide whether her relationship with her siblings is worth all of the money that she would have to give up in order to do the right thing. Joint tenancy also has other challenges associated with it. For example, let's say with a husband and wife who've been previously married and have children and assets from previous marriages. Let's say that they own a house together. This is a very common circumstance. You know the Brady Bunch? Many relationships today are like the Brady Bunch. Well, let's say that the husband dies first and his wife is the joint tenant with rights of survivorship. Now she inherits that property lock, stock, and barrel, and she then has the ability to send it on to her children at the expense of her deceased spouse's children. This is what we call the lottery effect, so that the first one who dies under joint tenancy, their family can lose because the ownership of the property goes to someone else. Also, joint tenancy can lead to personal liability. Let's say that mom and daughter are on the same bank account. The idea is that it would avoid probate, which is correct. Joint tenancy does a great job of avoiding probate at the first death, but it does nothing to avoid probate at the second death. So mom and daughter are on the joint account or joint owners on a piece of real estate, and the daughter has a car accident and is sued. They do a search of all of the daughter's assets and they find this account with mom with whom the daughter is a joint tenant. So now mom and her bank account or her house are parties to this lawsuit against the daughter. So these are some of the unintended consequences that can occur from joint tenancy. As I mentioned, joint tenancy works great at the first death but doesn't do anything to transfer property at the second death. Proper planning is important to avoid the pitfalls that come with joint tenancy. So if you'd like some assistance and more information on how we can adapt or change joint tenancy to achieve a better result for you and your family, feel free to give us a call at 877-438-7878. Thank you.